See you all here this morning, and a warm welcome also to all those who are following us from the Sea House and who I can hope can hear and see the Bürgersaal all right. Welcome to this morning's session. Maybe I'm just going to explain in 2 words how we're going to be set up this morning. I will deliver a keynote address about the European Union and social cohesion, which will hopefully last for about half an hour, and then we'll have a discussion. And immediately after that, we are going to start with our workshop, one workshop in which the students of Oliver Radkolb and myself will participate, and another one which is going to take place in the Sea House for the participants who are already there, and which will be guided by Michaela Windischkretz. So without further ado, I will start, and I would start by, well, perhaps defining the subject a little bit, yeah? European Union and social cohesion. By social cohesion, for our purposes today, I mean reducing social inequalities within and across member states. And I would perhaps start from the perception that one sometimes sort of gets that the European Union doesn't necessarily do enough in that area. Yeah? That is what one can sometimes get as feedback, that the European Union is not sort of sufficiently interested in the social question. And rather than proving or disproving that perception, I would provide us with some background to better understand actually what the European Union does and what it can do in that field. And I would start with a quote which shows that the social question was actually present in the minds of the drafters of the treaties, in fact, since 1957, because this is a quote from the preamble to the Treaty of Rome of 1957, establishing the European Economic Community, and in which we can see that the idea of the drafters was basically to ensure economic and social progress and improvement of the living and working conditions through eliminating barriers. Yeah? So during that first phase, the idea was that it was the elimination of those barriers, basically the creation of a common market that was supposed to improve also the social condition and to bring the peoples of Europe closer to each other also in social terms. Social cohesion is achieved on the one hand through regulation and on the other through redistribution between states, and we are going to follow very quickly those 2 aspects over time. So what we see in the EEC treaty at the origin was that there is a chapter on social policy, but it is mainly soft law. Yeah? Member states talking to each other, guidance being given, and so on. Nothing really very tangible, except one thing, namely the provision that men and women should be paid the same for the same work. Yeah? The article that at the time was Article 119 EEC, which is nowadays 157, I hope. I'm terrible with those numbers. TFEU, equal pay for equal work. And that was a hard law rule. Yeah? And of course it has a social component to it, only that at the time it was seen essentially in an economic function, because equal pay for equal work was a principle that already applied in France, and France did not want competition from other member states where basically women could still lawfully be paid less than men for the same job. So this was written into the treaty rather in order to ensure fair competition and fair movement of labor between the member states. Nevertheless, it was sort of reinterpreted by the Court of Justice in 2000, when the court essentially said that the economic aim of that provision was secondary to the social aim, which gave expression to a fundamental right. Yeah? So you can see that there's a big shift in the emphasis, a shift also brought about by the fact that there's a much greater emphasis nowadays on fundamental rights, which got into European Union law, so that nowadays one clearly also sees the social component of that particular provision, which at the origin had a slightly different intention. Next to those regulatory aspects, there was the European Social Fund, on which the original member states had quite a say, yeah, meaning that it was actually up to them, up to the 6 founding member states, basically to decide between them how the money of the European Social Fund was going to be allocated. And the initial intention was basically to combat unemployment in the south, essentially in southern Italy, in the Mezzogiorno, and to retrain migrant workers who moved, again, essentially from Italy to the north, to Germany, France, and Belgium. An observation that is often made in this context, and particularly by Fritz Scharpf, who refers to the joint decision trap, is that rules on economic freedoms, yeah, are basically cast in stone because they are written into the treaties, yeah, and rules on other aspects, such as social policy, yeah, are based on the treaties, are adopted by view of legislation, which then needs to sometimes give way to the treaty rules. Yeah? All the legislation needs to be assessed as to its legality in accordance with the treaties, which is a certain risk that economic freedoms sort of prevail over other aspects. But initially, the idea was simply that there should be welfare gains for everyone living in that community through basically the free movement of workers between states. And social regulation during that first period was essentially seen as flanking measures of the free movement of workers. Now, how did this evolve subsequently? It evolved in the Single European Act in 1986, and then again in the treaty establishing the European Community and the European Union in 1992. Social cohesion became formally and explicitly a task of the European Community, mentioned in Article 2. The chapter on social policy was revised. We then got a legal basis, for instance, for rules on health and safety at the workplace. And a new chapter was added on cohesion, including social cohesion. And the financial resources that were allocated to social cohesion in particular increased at that time from around 4 to around 8 to 10% of the union budget. So there was, at that time already, potential for more hard law, yeah, for more rules that could be adopted on the basis of the treaties, but there was still a lot of soft coordination also going on in the social field. When we look at legal basis for social policy, so to speak, yeah, we are not confined to looking at those provisions of the treaty that specifically deal with social issues, but we need to look also at the legal basis for the internal market, because obviously different rules on social standards, yeah, and on how workers are to be treated in the various member states all have a very important impact on free movement between member states. And in order to, well, to bring about that free movement without borders between the states, one can argue that it is necessary to harmonize also on social aspects on the basis of internal market legal bases. And these internal market legal bases have always been there and could be used also to advance social goals, essentially. So there is perhaps not even the antagonism between economic freedoms and social rights and social aspects is perhaps not even as great as it may seem or have seemed to some. And I would like to underline this by looking at one particular example, namely the so-called posting of workers. Posting of workers refers to a company that employs workers in the state in which the company is established, in its home state, yeah? And then sends them, posts them to a host state where they are then going to perform work at a shipyard in France or other things that can come to mind. But they remain employed in the home state. Yeah? And what the fundamental freedom of the internal market that is at issue here is not the free movement of workers, because the worker doesn't move to, as a worker to another member state, to be employed in another member state, but it's the freedom to provide services of the company that employs those workers. Yeah. And the company and the workers are therefore in principle subject to the legislation of the home state where the company is established. Now, that is something that has been seen as unjust, yeah, by workers and trade unions in the host state, because it can sometimes lead to a phenomenon of social dumping. And cases about this and about what legislation to apply have come before the Court of Justice. The Court of Justice holding, in particular, in a case called Rush Portuguesa in 1990, that it is justified to apply the legislation of the host state. So where these workers come from a country, well, where they are badly protected, basically, low wages and other guarantees, and move to, well, a state in which there is higher protection, higher wages, etc. It is a justified restriction on the freedom to provide services of the company in question, yeah, that you apply some of the French, so to speak, legislation in that case to the workers coming from Portugal, for instance. Yeah? Since that is an obstacle to the freedom to provide services, there was then an incentive to harmonize this, which is what the union legislator did in an initial directive of 1996 concerning the posting of workers, and where the legislator said only some rules of the host state apply. In some cases we think it's justified. In other cases the workers and everyone else should be happy with the application of the rules of the home state, sort of the low protection, so to speak, country. Now you can imagine that that is an issue which can give rise to particular tension in cases in which there is a great imbalance between well, the levels of protection, the levels of wages and social security benefits between the various states. And that is, a divide that has sort of begun, I would say, with enlargement in 2004, and really been a contentious issue between Eastern and Western member states, which is why the issue has come back on the table later on, as I'm going to explain in just a moment. What happened then in the mid-2000s, though, was that the Court of Justice, in its case law, became somewhat astonishingly liberal. Yeah? Liberal in the sense that it allowed for the application of the rules of the member state to which those workers were posted, and where the trade unions and workers in that member state said, well, we need to apply our rules to them, only to a very limited extent, and interpreted this directive that was meant to grant them that protection quite narrowly. The case of Laval really sort of epitomizes that. Laval, a Latvian company that used Latvian workers to refurbish a school in Sweden. And the Swedish construction union then wanted Laval to apply Swedish collective agreements. And since Laval was not prepared to do that and said we are not required to do it, yeah, the Swedish construction union started industrial action, yeah, basically impeding the refurbishment of the school from being carried out. Laval brought an action, and the question came before the Court of Justice, in which the Court of Justice, as already hinted, ruled that the directive was exhaustive, yeah, and that the workers for Laval, the Latvian workers, didn't need to get anything more than what was strictly foreseen in the directive, and therefore the industrial action of the Swedish construction union was unjustified, yeah, and in an unjustified manner impeded the freedom to provide services of that Latvian construction company. Yeah. Now you may imagine, yeah, that the ruling of this kind, which went into very far in the direction of liberalization rather than social protection, yeah, contributed actually to even more tension and made it necessary to bring this back to the table of the union legislator. A small aside, yeah, in the field of economic coordination and soft law, we should not forget that during that time also, 2008, 2009, there was the big financial crisis. The big financial crisis led to the introduction of what we call the European semester, starting in 2011 as an important measure of coordination of economic policy. And in that economic policy, well, what the European Commission and the Council are looking after very strictly is fiscal discipline. Yeah? There is the so-called excessive deficit procedure, which is hard and which can give rise to even very significant fines on member states who have an excessive deficit. At the same time, coordination in the social field is soft. Yeah? There are policy recommendations addressed to the various member states on what they could or should do in the social field without any hard law consequences. Again, this is rather natural because that's what the treaty provides for. Yeah? It is clear that member states are supposed to respect, in principle, unless there is an emergency break as we currently have it, the excessive deficit procedure and rules, whereas in the social field, obviously, a lot still lies with them. Which brings me already to the situation today. Today, basically, after the Lisbon Treaty of 2009, what we have is, firstly, a clear statement that the European Union professes to a social market economy as an objective. That is set out in Article 3.3 of the Treaty on European Union. And then we have this classification of competencies of the European Union into exclusive, shared, and supporting competencies. And there we see that the policy, the social policy, and cohesion policy are labeled shared competencies, which is something that was actually obvious already before it was written into the treaties, but nevertheless significant to note. Obviously, it's not only the European Union that acts in the social field. Yeah? I would even say that the basic action and the basic powers in the social area quite clearly lie with the member states. And the European Union can only do certain things in that area. And many other limitations come into play here as well. So we have in the treaties on the European Union the so-called principle of conferral. Yeah? The European Union can only do those things with which it has been entrusted. Yeah? Sounds obvious, but nevertheless is sometimes useful to repeat so that we don't simply expect too much from the European Union. Another principle, of course, is the principle of subsidiarity. Yeah? The European Union should only be doing things that the member states cannot do themselves. Yeah? And that also is, of course, a very important principle in when it comes to regulating on social matters. In that particular area, quite a number of other limitations are written into the treaty. On some issues, the treaty says that there can be no harmonization. Yeah? The measures of the union can be supporting what the member states do, but they cannot harmonize a particular matter. Other things are completely excluded. Yeah? There can be no harmonization, there can be no legislation on pay. Yeah? No legislation on the right of association, on the right to strike, or the right to impose lockouts. That is just excluded from union competence altogether. In other areas, there's another differentiation, which lies in the fact that the union legislator, the council, needs to decide with unanimity on certain matters, and only in others there is qualified majority. There's the possibility to move from qualified majority to unanimity if the council unanimously so decides. But that, again, shows to what extent member states, when they confer powers on the union, are actually careful in that social field and don't want the union, in fact, to do too much. In the field of cohesion, perhaps only one quick word. Whereas in the beginning, the aim was to basically support workers moving between member states, and the budget was relatively low. The budget has been increased, as already stated. At the same time, cohesion policy came with more and more conditions, and it was more and more at the central union level that the objectives of those cohesion measures were decided, and this so-called conditionality has been reinforced over time. Yeah? So, of course, when you give powers to the union and when you tell the union to distribute the money between the member states, you then also need to expect the union to impose certain conditions for that. And I would just remind in that context of the so-called rule of law conditionality. Yeah? So nowadays, all these union monies that are given to member states are given on the condition that the money is then not only properly spent in the member states, but also that the member states themselves control through due process, yeah, and the functioning judicial system whether the money is actually spent properly. So what have we seen in the last two commissions? Yeah, the Juncker and von der Leyen commission. They have been, I would say, quite attentive to these allegations that the European Union is not doing enough in the social field. And Jean-Claude Juncker announced, perhaps already in this speech in front of the European Parliament, from which Nikolaus Forger quoted the other day, in the case of Ms. von der Leyen, that the European Union should get a social AAA, basically. That was the idea that he put forward. And to some extent, I would say that Ursula von der Leyen tried to follow in his footsteps. And I would just want to point very briefly to four recent developments. So the first one is equal pay for equal work, by which we mean a revision of the Posting of Workers Directive. The second is the European Pillar of Social Rights. I will turn to each of them in just a moment. Those two things were still done under Jean-Claude Juncker. And Ms. von der Leyen, shortly after she came into office, came out with a proposal on minimum wages, mind you, yeah? Even though we have a prohibition on the regulation of pay in the treaty, so tricky exercise. Two words about that in just a second. And finally, I would also mention in the context of the, well, basically climate change legislation, the climate package, where the European Union is supposed to become fit for 55, as you all have heard in the media, reducing emissions by 55% until 2030. That's also needed in the view of the Commission, which is probably to be shared, to be accompanied by measures supporting those who were going to be hit hardest by this transition. So very briefly on these different measures. The first one is a revision of the Posting of Workers Directive. Yeah? I told you that the initial directive was from 1996, provided for certain rights of workers in the host member state, the state to which they were posted. Yeah? Then the Court of Justice interpreting all that very strictly, so that really no more rights could be invoked by those posted workers, and where now the legislator took that into its hands by bringing about a number of improvements. What is interesting to note here is that when the Commission made its proposal on this directive, the principle of subsidiarity, yeah, according to which the Union should only be doing things that the member states cannot, broadly speaking, yeah, played an important role. And a number of member states, national parliaments, indicated that this directive shouldn't be there at all, yeah, and raised the so-called yellow card. Yeah? National parliaments, when they don't agree with the Commission making a proposal because they think it violates the principle of subsidiarity, can say that. And if a significant number of those chambers of national parliaments says that, it means that there is a yellow card and that the Commission needs to think about that again. The yellow card was triggered. The Commission nevertheless went ahead with its proposal, and ultimately, after long and hard negotiations, it was finally agreed on and brought about improvements essentially for workers in the state to which they are posted. I won't go into the details of that. Remuneration was to be understood more broadly. Collective agreements and the benefits of collective agreements were to be conferred on posted workers to a larger extent, and they were also supposed to enjoy other basic rights. And what is also interesting is that there are stricter rules on long-term posting. Yeah, you can imagine, for instance, that a company posts a worker for a particular period of time to work on a construction site, which goes on for quite some time. And then there is a time limit after which that worker is meant to enjoy all the rights. Yeah, really all the rights as if the worker was permanently working in the host member state. Yeah? Now, to prevent that from happening, there is a certain incentive to replace those workers after a certain time. Yeah? So you simply send someone else and you say, well, that worker has now only just arrived, so has to wait for the maximum duration again. And there is a rule in the directive which prevents that and which says that you need to, where the worker is clearly simply replaced and in reality the work continues and it's the same job that is being carried out, then you need to aggregate the periods and the worker, the replacing worker, will then enjoy the relevant benefits more quickly. The second major initiative by the Juncker Commission was the so-called European Pillar of Social Rights, sort of a hybrid, actually declaratory document, which contains 20 principles and rights, and which has been proclaimed by the presidents of the three political institutions, the Parliament, the Council, and the Commission, at a social summit in Gothenburg in November 2017. It's divided into 3 chapters dealing with equal opportunities and access to the labor market, with fair working conditions, and with social protection and inclusion. All those principles touch upon, on the one hand, things that are fundamental rights anyway, in which case it's a simple restatement. Yeah? Things that the Union can do, and sometimes things that the Union cannot do, and where the member states actually are called upon to act. Yeah? So in that case, it's really more sort of a recommending nature, and the pillar of social rights is essentially programmatic in character, drawing the attention to social issues that need to be looked into and on which the Union and the member states jointly are meant to follow up. And this is, for instance, what happened with this proposal on adequate minimum wages, where when the Commission made the proposal, the von der Leyen Commission, after 1 year in office, made the proposal, said, now we are implementing principles 3, 6, and 9 or something like that of the European Pillar of Social Rights. Very delicate, obviously. Ms. von der Leyen announced that already in her speech in the European Parliament in July 2019, and already at the time the legal constraints of making a proposal on pay were well known. And the proposal that ultimately came out was a proposal that essentially is addressed to all member states when it comes to encouraging social dialogue, when it comes to pay, collective negotiations and things like that. That's for all member states. But only member states that already have or will introduce at some stage statutory minimum wages are covered by other rules, more specific rules, on how to determine the adequacy of wages. So it's really not on the substance, how much people should be paid, which is clearly off limits for the European Union, but it concentrates on what a member state is meant to take into account when determining minimum wages. And even though one may expect something like this to be actually incredibly contentious, ultimately a political agreement on this text has been achieved as recently as June 2022. Finally, the Just Transition Fund, only a very brief word on that. In the context of the policy to combat climate change, money is set aside basically to assist those sectors, those persons in the member states who will be hit hard because they will be out of a job. So efforts being made to reskill them and to provide them with assistance seeking jobs and similar initiatives. Which brings me to my very brief conclusion, which is basically simply just a summary of what I have explained. So at the origin, social aspects were taken into account basically in order to facilitate free movement and addressing the sometimes negative consequences that could arise from free movement in the social field. Whereas today, simply since European integration at large has broadened, we have social aspects on a great variety of fronts. We have them as a core of commonly desired standards where the Union wants to foster and monitor their implementation through the implementation of that pillar of social rights in particular. We have some harmonization via minimum requirements, for instance, the initiative on fair wages. We have an integration of social considerations into other policy fields, such as in the Just Transition Fund, where in reality we're talking about climate change policy. And finally, we have a stronger, I won't go into the details of that, and hopefully also more coherent financial contribution to social issues from the Union budget. And I will leave it at that. Thank you very much for your attention, and I look forward to the discussion.